Pre-employment drug tests and the drug testing of employees in the workplace are hot issues for employers, employees, and unions. I'm Dan Ringer, and we'll talk about drug testing right now on The Law Works.
From West Virginia Public Broadcasting.
Closed captioning for The Law Works is made possible by a grant from the Monongalia County Bar Association and by the Dietzler Family Foundation. People helping people.
The Law Works is made possible by the generous support of the West Virginia State Bar, the West Virginia Association for Justice, and by ALPS, providing protection and peace of mind for West Virginia attorneys and their clients since 1988.
When can and should an employer ask a job applicant or an employee to take a drug test? My guest is attorney David Morrison. David, thank you for joining us.
Thank you.
What I just said implies that drug testing may not always be a good idea. Why can't an employer drug test his employees whenever he/she wants to?
In West Virginia, there's a constitutional limitation on when employers can give drug tests. In our Constitution, we have a right to privacy, and our state Supreme Court has held that the general rule is that employers cannot give drug tests to employees because it invades their privacy. There are exceptions, but that's the general rule.
The right to privacy comes up a lot in the law, and it has been used in cases ranging from a stash of pornography in your foot locker to what's in your school locker to, well, the abortion issue, whether you have a right to privacy stemming from involved in that. So drug testing also is involved in the issue of privacy.
Yes, for a number of reasons. What is in one's system is private information. So if the employer is seeking that information, it may constitute an invasion of privacy. The act of doing the drug test itself involves privacy. I mean, the act of urination, for example, when you're doing a urinalysis, is private.
Well, how does that become a privacy issue? Peeing in a cup, I can understand you might not want people watching you do that, but you just walk into a stall and do the deed and come out and hand them the sample, right?
Well, yes and no. I mean, often as part of the drug testing process, the act of urination itself is observed sometimes because of the concern.
Tend to make it a little harder, maybe.
Yeah, of the concern of adulterating samples. But in addition to that, when you give a drug test, whether it's a blood test or a urine test, the information that's obtained in the lab analyses is much broader than just whether or not you're using drugs. People have a lot of privacy interest in what's in their system, so to speak. So it is very private information.
So if I'm taking medicine of one sort or another, it might show up in the drug test results.
That is correct. That may show up in the drug test results. If you're female, whether you're pregnant or not would show up in the drug test results. So,
well, some of those things become important in the workplace. Whether I'm taking medications for epilepsy or for diabetes, are questions. The questions about those things cannot be asked of me in the employment process normally.
Correct. Because of the Americans with Disabilities Act and our state Human Rights Act, which is fairly equivalent.
And similarly, you may not ask a woman if she's pregnant or planning to get pregnant normally.
That is correct.
And I say normally because there are exceptions to all of these things in
that's why
unusual circumstances, right. But in the normal course of business, if I'm going to go to work for a big box store, they're not allowed to ask me if I'm pregnant or if I'm epileptic or diabetic or whatever without a very particularized good reason for needing to know that.
That is exactly right. It has to be job related to get that information.
An airline pilot, they might ask him if he's subject to having seizures or is epileptic because you don't want an airline pilot to have a seizure.
That's correct. That would be part of the application process and also part of the pre-employment testing process for people in those types of positions.
So they can't give me a drug test because it might violate my right to privacy.
That is correct.
But doesn't the employer have an interest in having employees who are not high as a kite working for them?
And that's why the case was the Twig versus Hercules Corporation case. In that case, the state Supreme Court tried to strike a balance between the right of privacy that the individuals have and the rights that employers have to make sure that they don't have people working that could injure other folks because they're working while impaired, or it could affect the way they conduct themselves at work, how they handle their job because of being impaired. So there are two exceptions that the state Supreme Court recognized to the general rule that you cannot give a drug test to someone who is employed by you. The first is if the employee is in a safety-sensitive job, which means that the employee could, while working impaired, injure someone else. That's the definition. Then under that scenario, employers have the right to give random drug tests to those folks, again, to protect the safety of their workforce and other people that may come on their premises. The second scenario is when the employer has a reasonable, objective, good faith suspicion that the employee is impaired while working, through signs and symptoms that we normally recognize when someone is impaired. If you have a good faith suspicion based upon objective evidence, then a drug test can be given in that circumstance as well. But those are the only two exceptions to the general rule.
The phrase good faith and the word suspicion seems to me to be fraught with problems. What is good faith and what is suspicion?
You need to have objective evidence that someone is using drugs or is under the influence of drugs or alcohol while at work. And the objective evidence typically is what you normally think of when you think of someone who's, as you say, high as a kite, and that would be slurred speech, glassy eyes, unsteady gait, they can't think, they're falling asleep.
I know a lot of people
things.
who apparently can't think, and that may just mean they didn't sleep well the night before.
Yeah, it's a different type of behavior than what the person normally exhibits, is what you're looking for.
Well, there's a joke that goes around kind of in the legal circles about the Supreme Court justice who said, I can't define pornography, but I know it when I see it.
It's in large part what you're talking about.
And that's what we're talking about with drug use.
Yes.
If I look at you and I think there's something wrong with him, that might not be enough. I would need to be able to articulate somehow that what's wrong with you appears to be related to drug use. You may smell like you've been using drugs. You may smell like you're drunk.
Yes. Any of those could be facts to consider. You're right, it's like pornography. You know it when you see it. You have to observe it. You have to be able to articulate what you observe. There are employers that actually have checklists, for lack of a better term, of the things that you could observe about someone that would give you an indication that that person is under the influence. And employers may wish to try to get a checklist of things to take a look at.
I would think that would be difficult.
You can't put everything in it, but it gives you certain things to consider, certain observations to make, and it's part of the training process. Employers have to be trained on what to look for in order to have the objective evidence to give the drug test.
Well, let's start at the beginning of the employment relationship. I'm going to go get a job. Do I have to take a drug test?
Well, it depends upon the employer. Many employers have pre-employment drug testing, and in West Virginia, it's perfectly legal to do a pre-employment drug test under state law. You still have the Americans with Disabilities Act complication, if you will, in that the employer can't give tests, medical tests of any kind, until post-offer. So in other words, you don't give everybody a drug test, you make the offer first, then give them the drug test.
So I like you, you appear like you would be a good employee. I'm offering you, I actually have to offer you the job, but you have to pass a drug test in order to be allowed to go to work.
You condition the job on passing the drug test. And that's
Now, do I have to have some good faith reason to believe that you might be using drugs before?
No, not at that stage, because the Supreme Court has looked at that. There was a case called, I think it was Bauman versus Walmart, and in that case, the court said that applicants don't have the same expectation of privacy that employees have. They don't have to go to work there, for example. So as a consequence, employers have the right to give the pre-employment testing to those who have not yet started working as employees.
This is starting to sound to me to be complicated, and in part, I think, because of this concept of expectation of privacy, and that kind of takes us back to where we were several minutes ago. Under general American law, we each have the right to privacy, and because we have that right under the Constitution, we have the right to expect to be left alone, to have our bodies and our property not bothered by other people, not examined by other people. So we have an expectation that nobody's going to literally or medically go poking around inside us. And so when you go to apply for a job, you have an expectation of privacy, but you don't have a reasonable expectation of being allowed to work for whoever the employer is. You have to meet their requirements first. And that's where the drug testing comes in.
That's where it comes in, absolutely. And as opposed to an employee who already is working there, meeting the expectations of the employer otherwise, that person has more of an expectation of privacy concerning what they do off premises, how they conduct themselves, and so that's when you get into the invasion of privacy problems as identified by the Twigg case.
And that comes about because the already employed person says, I took your interviews, I passed whatever tests you chose to give me, I got the job, I've been working on the job, I'm working on the job satisfactorily, I have the expectation that I will now be left alone unless there is a good reason why I shouldn't be left alone.
That's a very good way to say it, absolutely.
I read your papers on this. So the pre-employment process, the person applies for the job, they're offered the job, and then they're told, give us some sort of sample that we can perform a drug test on. What kind of samples might be involved in something like this?
Typically it's a urinalysis because that's less intrusive from a privacy standpoint than would be a blood test. When you're drawing blood, it's much more intrusive. So typically
They're
it's
poking
also
holes in your body. Yeah.
Yeah, and it's also less expensive. I mean, urinalysis is much less expensive. I think I checked this out recently, and a local provider, it was $44 or something like that for a urinalysis to be performed by an employer that was having a lot of them done. As opposed to a blood test, it's much more expensive, much more intrusive. The other form of drug test is the hair test, rarely used in the employment setting because the hair traps the chemicals of your body for a long time, and it might show what you were doing several years ago, and really an employer doesn't have an interest in that or shouldn't. So hair is very rarely used.
As I understand it, hair and fingernails, things made of like substance, kind of takes a picture of your biochemical makeup at the time those cells are formed, and then they'll grow out, and they might be there for a very long time. In fact, if you know a woman or a man, either for that fact, who has waist-length hair, the hair at the very tip is going to be a photograph of their body, in a sense, at the time that hair first grew, and that could be somebody's entire lifetime contained in their hair.
And that's why it's really not a good picture of whether or not someone, at the time they're applying for a position, would be under the influence of drugs.
Well, anecdotally, in the news just relatively recently, Lance Armstrong, the bicyclist who won the Tour de France 7 times, has been under suspicion by certain authorities of having used illicit drugs to enhance his performance, And the most recent thing they did, the French authorities came back and said, let us have a hair sample. And apparently he gave the sample, but that sample will allow them to go back quite a distance into the past to see if he was using drugs. And hence a hair sample would seem to be particularly prone to being violative of this expectation of privacy.
No question.
If my hair is 5 years old at the tip, 5 years ago I had a real expectation that you, David Morrison, were not going to be checking my hair for drug use or checking me for drug use.
That is correct. And then you also get into some ADA issues with that.
Americans with Disabilities Act.
Yes, and those issues are that when you test someone, you can only, if you give a medical test to someone who's applying for a position, you can only test them for things that are relevant to their job. In other words, if you have a back, your job is going to require a lot of heavy lifting, they have the right to give you a medical test before you start to test the strength of your back. And now they can't, if you are a clerical employee who never have to lift anything, then you wouldn't obviously have a test of your back strength. So if it's a medical test, then it has to be limited to it has to be job related and limited to what you're doing. Interestingly there, the ADA actually draws a distinction between a test for alcohol, which is considered a medical test, and a drug test, which under the ADA is considered not to be a medical test. And
we'll schedule another program and maybe bring in some physicians to talk about that.
That's how the ADA makes that distinction. So if you are giving an alcohol test as part of your pre-existing or pre-employment process, it better be because that person while working could be impaired and could injure someone else. I mean, like a bus driver, you would have to give an alcohol test to a bus driver, but a clerical employee you probably could not give an alcohol test to. You can give a drug test, but not an alcohol test.
And all of that is in large part defined by federal law.
No question. Yes. Well, and state law. I mean, our State Human Rights Act pretty well tracks the ADA, Americans with Disabilities Act, as well.
But it's federal law that identifies bus drivers and airplane drivers and people like that who have the safety of large numbers or even small numbers, I suppose, of people in their hands.
Correct. Yeah, the Department of Transportation has a set of regulations that govern all of that. They're pipeline workers, the folks that work in the aviation industry, folks that have a CDL, commercial driver's license, all of those are governed by DOT, and there's a whole set of regulations you have to follow for drug testing.
Does everybody in these pre-employment figure tests, does everybody get tested?
No. Well, it depends. You know, I'm a lawyer. Everything depends. But
that's why we do these shows.
Yeah, that's right. If the employer wants to test everybody who applies for drugs, the employer can do that post-offer. So it just depends upon what the employer wants to do. I mean, even
that's an
clerical
expensive
employees,
undertaking.
Sure.
Yeah, I think you said $44 per test with a large number of urinalyses.
Right, which I assume involves a volume discount, but I don't know that.
I didn't want to say anything about that. Yeah. But if you have 100 applicants for a job and 100 jobs to be filled and you offer jobs to all 100, in theory, you could, if you wanted to, have all 100 of them take a drug test.
That is correct.
But you can have fewer numbers do that, just kind of spot checking?
I wouldn't recommend that, because then you get into discrimination issues. Discrimination, as you know, by definition, is different treatment under similar circumstances. So you wouldn't want probably to just pick and choose unless you're doing it on some objective basis, like only testing those who are going into safety-sensitive positions. That would be a way to limit your exposure in terms of dollars paid out at the early stage. But the discrimination becomes a problem. Let's assume that the way it turns out, you only test folks over 40, or you only test females or something, or there's a higher degree of females that are being tested, then you get into discrimination issues.
Let's talk for a moment about the people who are already employed in the workplace, and particularly in the coal industry. There's been a lot of discussion about drug testing of coal employees or coal industry employees. What's the status of that?
MSHA has currently a regulation that says that employers are to prohibit the use of drugs or the sale of drugs on the premises. They're also to prohibit people from working while under the influence. It's just sort of a general regulation now.
In the mining industry.
In the mining industry. That MSHA stands for the Mine Safety and Health Administration. MSHA also has proposed regulations right now that have been talked about for a while. They're in the comment stage, and those regulations would require drug testing for individuals in safety sensitive positions in the mines. Not the mine clerks, but the miners working underground. Most of them are in safety sensitive positions. So those regulations are being discussed right now, and there are pros and people in favor and people opposed, and but it's still going through that process.
Who's opposed to drug testing for people in safety sensitive positions?
In the mining industry, for example, the United Mine Workers of America have come out against drug testing, mandatory drug testing. So there are people who are opposed to it for various reasons. I will tell you that there are some other unions that are also opposed to it, and I couldn't explain why necessarily, but I know that they are.
Well, I can think of some reasons, perhaps. Not all drug tests are completely reliable.
That would be one.
In fact, the easier, cheaper drug tests are fairly notorious for being wrong. There are some inexpensive drug tests, almost in the form of do-it-yourself kits, that will give false positives. In fact, that's the real concern, I think, with these people who are opposed, or groups who are opposed to drug testing for classes of employees, is that you'll get a false positive on the drug test, and a false positive on a drug test is like paint. Once it gets on you, it's really hard to get it off, because you've now tested positive, and well, how do you challenge that?
Well, another, Dan, another concern I've heard raised about the drug testing in the coal industry is that it constitutes more regulation by employers of off-duty conduct, and employees should be able to do off-duty what they please as long as it does not impact on the employer.
I can get drunk on my time as long as I'm sober when I go to work.
Right, and that might still show up in your urine, though, and so you're perfectly, you don't really, you're not working while impaired, but it's still in your system, so that could give rise to, it's almost like a false positive. It's not really a false positive, it's close to it, because they're not working while impaired.
It's positive, you used something,
right,
but it didn't affect you, and it's the ability to affect you that's the concern.
And I know that's another concern that has been expressed. But that, as I said, those MSHA regulations are being considered right now, and the statistics, there are some bad statistics out there in terms of the number of people who are using drugs in this country and the number of people who are working while using drugs, and that is causing lots of employers concern, especially in the coal industry where safety is a primary issue.
I have seen some of those statistics. In fact, I have some here. 16.7 million people over the age of 18 are using illicit drugs in this country, at least according to one source. 16.7 million, and of that 16.7 million, 12.5 million of them are employed. So they're working in the workplace while simultaneously in their lives using drugs. And now you have to draw a line between whether the use of those drugs is affecting their employment. And we have a cultural conundrum, because we have laws against using illicit drugs, yet we're excusing it to allow people to go to work. What's your answer to this?
There is no answer to that. I mean, it is a conundrum. And that's the primary issue for most employers with whom I work is safety. I mean, that is the primary issue. And I will tell you, in the coal industry, that's what's driving the coal companies for wanting more testing is the safety issue. And we have all of these horrendous accidents that occur in the coal industry, and I don't know how many of them are related to drugs, but I know that some are, and the goal here is to eliminate the safety risks associated with it.
And that's kind of the final statistic. I think these are MSHA figures, but according to them, approximately 20% of the people who die nationally in workplace accidents have illicit drugs in their system. 1 in 5 people who die in the workplace have illicit drugs in their system. It is a problem. David Morrison, thank you, sir, for being with us.
Thank you.
Thank you also for being with us. On behalf of the Law Works, I'm Dan Ringer. Good evening. If you want to know if you need a lawyer, you can discuss your problems with a lawyer by calling the West Virginia State Bar Helpline, toll-free Tuesday evenings from 6 to 8 at 1-800-642-3617. On the LawWorks webpage at thelawworks.org, you'll find a complete listing of all the LawWorks show topics, information on how to obtain copies of the program, and additional information about this show's topic. You'll also find a list of legal resources that can help answer your legal questions. If you would like to suggest a topic for a future The LawWorks show, you can send us email to thelawworks@comcast.net.
The Law Works is produced in cooperation with the West Virginia State Bar, the Mountain State Bar, the West Virginia Association for Justice, and the West Virginia University College of Law. The Law Works is made possible by the generous support of the West Virginia State Bar, the West Virginia Association for Justice, and by ALPS, providing protection and peace of mind for West Virginia attorneys and their clients since 1988.
From West Virginia Public Broadcasting.